Section 230 of the Communications Decency Act.
Those infamous 27 words.
Exactly. And our mission today is to dive straight into the white-hot center of the debate around this law, this increasingly popular and often very politically charged idea of just removing it, or, radically reforming Section 230 entirely.
Right.
To its advocates, this change is framed as the one internet hack that could save everything.
I've seen that phrase a lot.
It's a surgical strike, they say, capable of curbing the unchecked power of algorithmic amplification and finally holding these dominant platforms accountable for all the societal harms they facilitate, from disinformation all the way to serious crime.
But to even begin to understand the severity of that proposed hack, you really have to go back to the beginning.
You do. We need to trace the legal origins of this massive liability shield, understand how the courts have repeatedly widened its scope over the years, and see how modern technology, we're talking specifically about proprietary algorithms, has fundamentally challenged what it was originally meant to do.
And then we can get into the major legislative proposals, what they're trying to accomplish, and maybe what chaos they might unleash instead.
It's an incredibly high-stakes conversation.
Yeah.
And you really can't overstate the paradox at the heart of this tiny law. Section 230 is, well, it's a true double-edged sword.
It absolutely is. On one hand, it's the foundational pillar that allowed the open internet to even exist at scale. It fostered this unprecedented wave of innovation. It allowed the explosion of user-created content. I mean, everything from Wikipedia and YouTube to, essential business tools and even legitimate law enforcement intelligence gathering.
Right, the internet we know today.
But the shadow side is profound. I mean, the way the law has been interpreted so expansively has created this zone of legal impunity that wrongdoers can just exploit.
So we see platforms being used as conduits.
Conduits for everything. Organized crime, child sexual exploitation materials, CSAM terrorism recruitment, cyberstalking, the distribution of illicit drugs, the very immunity that was meant to protect good faith moderation. Well, to a lot of critics now, it seems to protect corporate indifference.
So our goal today isn't to take a side. It's to give you the comprehensive knowledge you need to navigate this debate for yourself. We need to dissect exactly how the courts interpreted this immunity so broadly and then ask that crucial question.
Can these proposed very aggressive reforms actually succeed? Can they realign the law with the realities of the modern, algorithmically driven internet without, completely destroying the engine of innovation they're trying to regulate?
It's a huge question. So let's start at the beginning.
Let's do it.
Okay, let's unpack this and really set the scene for the early days of the internet. We have to go back to 1995.
A different world.
A totally different world. This was before broadband, before Facebook, before the very concept of an app even existed. We're talking about a world where only about 20 million American adults had access to the web.
A tiny fraction of what we have today.
And the legal system, well, it was facing this completely new medium and was just struggling to figure out a basic categorization. Were these online services, publishers, like a newspaper, responsible for everything they printed?
Or were they more like a passive distributor?
Yeah.
Like phone company or bookstore, just facilitating the transmission of information?
And that categorization wasn't just some academic exercise, right? It meant the difference between massive financial liability and, well, complete freedom to operate.
Absolutely. And that struggle created an immediate, confusing, and frankly contradictory legal landscape. That's the mess that Section 230 was explicitly designed to fix. The whole conflict really centered on how you assign defamation liability for third-party content.
Okay, so let's talk about the two cases that created this conflict. The first one suggested a more passive model, right? That was Cubby, Inc. v. CompuServe.
That was in 1991. CompuServe was one of those early online services, and they were hosting all sorts of user-created content. In this case, it was a newsletter where some allegedly false and defamatory statements appeared about a competing service.
And the court found CompuServe not liable? Why?
The reasoning was key. The court saw CompuServe as a passive entity. They said it lacked the practical ability and this is the important phrase, had no opportunity to review the content before it was uploaded to their servers.
So they were treated like a distributor.
Exactly. Like a newsstand or a bookstore in the physical world. I mean, those places aren't generally liable for every defamatory word in the thousands of magazines and books they sell, unless you can prove they had specific knowledge of the illegal content. So this case, Cubby, it established a really strong precedent for limited liability.
It seemed like common sense. But then, just 4 years later, the legal system just tripped up spectacularly with Stratton Oakmont v. Prodigy Services Company in 1995. This is the case that really triggered the whole thing.
This is the one. So Prodigy was another one of those early dial-up services, kind of a walled garden, as they called it. And they were held liable for allegedly defamatory content posted on one of their public message boards.
And this content claimed that the investment bank founder, Jordan Belfort, had committed securities fraud.
The irony here, for those of you keeping score at home, is just,
Oh,
it's so rich. The post later turned out to be factually true.
right. This is the Wolf of Wall Street, Jordan Belfort.
The very same. He was later convicted of securities fraud, but that didn't matter for the case. Prodigy settled, and this damaging legal precedent was set.
And what made that precedent so damaging? What was the key difference between the Prodigy case and the CompuServe case?
One phrase: editorial control. Prodigy actively advertised itself as a family-oriented service. They set rules of civility on their message boards, and crucially, they sometimes enforced them.
They moderated.
They moderated. And because they exercised some editorial oversight, the court essentially said, well, if you act like a publisher by moderating content, then you are liable like a publisher for everything on your platform.
Oh, wow.
This created what became known instantly as the moderator's dilemma, and, crucially, a powerful, perverse incentive.
Let me guess. The Prodigy decision sent a message to every other online service out there.
A chillingly clear one. It said, if you make any attempt to moderate, if you try to keep your site clean or enforce rules or move something obscene, you risk being held fully liable for all third-party content on your entire platform.
So the safest legal path, the path of least resistance, was to do nothing.
Do nothing.
Yeah.
Adopt the hands-off, anything-goes model, just like CompuServe,
Yeah.
to minimize your legal exposure. It was a terrible choice. Either you run a filthy, unmoderated forum or you face the risk of massive business-ending liability.
And this is what got Congress's attention.
Immediately. The fear expressed by the lawmakers who drafted Section 230, Representatives Christopher Cox and Ron Wyden, was stark. They believed that unless they took corrective action, the brand-new Internet would quickly just descend into nothing but a sewer, stifling the very innovation they were trying to foster.
So the core driving purpose of Section 230 was really twofold, born directly out of that Prodigy disaster.
Right. They were determined to ensure that, one, good faith content moderation should not be punished, and two, to protect innocent third parties, the platforms, from being made liable for unlawful acts committed entirely by other people.
So the statute was really an elegant early internet attempt to balance things, to put the liability on the person who actually created the content.
While letting the platforms host that content without the constant fear of being sued into bankruptcy. It was designed to solve a very specific problem.
Which brings us to the law itself. Section 230 is so often talked about as this impenetrable shield, but it's crucial to understand the specific language. It's not actually absolute immunity.
That's right. And it's broken down into two distinct protections. The law essentially provides a double layer of defense.
Okay, what's the first layer?
The first and most famous is Section 230C1. This is the broad immunity provision. It protects interactive computer service providers, and, this is important, it also protects users from being treated as the publisher or speaker of information provided by another person.
And publisher or speaker is the key legal phrase here, right? Because that's the definition that triggers liability in defamation or negligence cases.
Exactly. By stripping the platform of that specific legal designation, subsection C1 applies to all the traditional editorial functions. Deciding to publish something, deciding to withdraw it, postponing it, or even altering the content. It creates what the courts have interpreted as a powerful federal immunity that shields platforms from most civil claims related to third-party content.
And that covers everything from defamation and emotional distress to
cyberstalking and negligence. The courts have upheld this incredibly broad reading time and time again, which is what gives the law its fearsome reputation.
Okay, so that's C1. Then you have Section 230C2, which addresses that original moderator's dilemma head-on. This is the Good Samaritan provision.
Right. It explicitly protects voluntary, good faith efforts to restrict access to material that the provider considers, and the list is specific: obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable.
Or otherwise objectionable. That seems pretty broad.
It is. And the critical part is that this protection applies even if the material they're taking down is constitutionally protected speech.
So this is what gives platforms the power to create their own community standards.
Exactly. It gives them the statutory latitude to set a bar that's much higher than what the First Amendment requires, without the fear of losing their shield for doing so. They can decide what's appropriate for their own house without becoming a publisher in the eyes of the law.
But as you said, the immunity is not a free pass. This is where the tension comes in. The platform can lose its immunity if it becomes what's called an information content provider, or an ICP.
Yes. The immunity is lost if the defendant, the platform, is responsible in whole or in part for the creation or development of the illegal content.
So what does creation or development actually mean in a legal sense? That seems like the central question.
It's the entire battlefield.
Right.
The judicial system has tried to define this through what's called the material contribution test.
Right.
This test asks whether the website's own actions or its architecture contributed materially to the illegality of the content or the conduct. So if a platform is just hosting something, it's safe. But if it's actively designing a system that compels or creates the illegal content, it loses its immunity.
The classic example you see everywhere for this is that 2008 Ninth Circuit case, Fair Housing Council of San Fernando Valley v. Roommates.com. Can you walk us through why that platform crossed the line?
Sure. Roommates.com was a website designed to, well, match roommates. But their architecture didn't just host user profiles. Their required profiling system actually forced users to state their preferences for roommates based on protected categories like race and gender.
Which is illegal under the Fair Housing Act.
A direct violation. So the court distinguished this from simple hosting. The website didn't just carry the information. The specific coded design of the site required the user to input discriminatory information just to be able to use the service.
They weren't just a bulletin board, they were creating the illegal content through their design choices.
That's how the court saw it. They found that the platform contributed materially to the illegality. They developed the content by structuring the input system that way, which made the platform complicit in the violation of the Fair Housing Act. This was a huge case because it showed that even passive software design, if it compels illegal behavior, can be enough to strip a platform of its immunity.
And it doesn't even have to be content hosted directly on the platform's site, which I think often surprises people.
That's right. We see this in a 2016 case, Federal Trade Common v. Click Media. In that one, an internet marketer was held complicit and lost its immunity because it gave advice to other content creators on how to generate illegal or misleading content, even though that content was technically hosted somewhere else.
So just by giving advice, they became a developer.
They materially contributed to the development of the content by offering guidance and infrastructure support. They were part of the creation process.
Before we move on to the modern crisis, we should probably quickly reiterate the existing statutory exceptions. I mean, we often hear that Section 230 protects everything.
And it absolutely does not. Section 230E explicitly lists areas where the immunity generally does not apply.
Such as?
This includes all federal criminal law. It includes intellectual property law. That's why copyright holders have to rely on a different law, the Digital Millennium Copyright Act, or DMCA. And critically, it includes laws related to sex trafficking, which were added by the FOSTA-SESTA legislation back in 2018.
So the law is supposed to be consistent with prosecuting crimes.
Yes, the law is intended to be consistent with the aggressive prosecution of all other federal crimes. Section 230 only blocks civil liability that's based on those publishing decisions.
So this whole legal framework from the 90s leads us directly to the central modern question. How are the courts supposed to interpret development when the architecture is no longer about mandatory text boxes on a roommate website?
But about these incredibly complex automated systems that are designed to maximize engagement at all costs.
Exactly. What happens when a platform's code is actively organizing, promoting, and targeting content specifically to keep a user scrolling? Does that count as a material contribution to the content's potential harm, like, say, promoting extremist views or dangerous behavior?
And that is the billion-dollar question that Congress and the Supreme Court have been grappling with for years now.
Let's talk about scale. Because the initial debate over 230 was, as you said, almost quaint. It was about whether you should manually edit a message board that maybe has a few thousand posts a day.
Right.
Now, we are talking about massive, dominant platforms whose entire economic model is predicated on actively amplifying certain content to billions of users, often without any regard for that content's quality or danger.
The reality has just shifted so fundamentally beyond the early internet's vision of a bulletin board. The modern intermediary isn't a simple passive host. It is, first and foremost, a commercial service for targeted advertising.
The business model changed everything.
It did. These companies designed these highly sophisticated, automated decision-making systems, algorithms, for one primary purpose: to predict and maximize user engagement and, by extension, advertising revenue. The motivation has shifted entirely from, say, protecting a nascent public forum to optimizing a vast global political economy of online advertising.
And that shift brings us right to the core of the algorithmic liability question. We have users and victims of harm seeking to hold platforms liable not just for hosting bad content, but for using these automated systems to aggressively recommend or organize it.
They're arguing that this active selection process moves way beyond passive hosting and actually constitutes content development, which should strip them of their immunity.
Right, and you see these algorithms acting as editors everywhere.
Absolutely. Think about it. Search engines weighting results based on perceived relevance or your location.
Hmm.
Online marketplaces displaying certain products over others. And of course, the most controversial examples are social media platforms sorting our feeds.
Like TikTok's For You page?
That's the perfect example. It prioritizes content based purely on an engagement prediction, often without any regard for who you actually follow. These algorithms are making active, complex editorial choices designed to maximize your time on the site, and in doing so, they can end up pushing radicalizing or harmful content in the process.
This exact tension was presented directly to the Supreme Court recently in two major interconnected cases related to terrorism: Gonzalez v. Google and Twitter v. Tumney.
Correct. The Gonzalez case specifically challenged Google's YouTube recommendation algorithm for promoting ISIS recruitment videos to susceptible users. The plaintiff's argument was that the algorithm was, in fact, active content development.
And the Tumney case.
Tumney challenged Twitter for just hosting terrorism-related content, arguing that this constituted aiding and abetting terrorism under a federal law called the Anti-Terrorism Act, or ATA.
So the plaintiffs were trying to use this other law, the ATA, to basically get around Section 230, arguing that the active promotion and hosting of this content was material support for terrorism.
That was the strategy. But the critical hurdle they faced, beyond 230, was the very high standard set by the Anti-Terrorism Act for what counts as aiding and abetting.
And what is that standard?
To meet it, the platforms needed to be found to have knowingly provided substantial assistance to a specific, defined act of terrorism. And the Supreme Court, well, they ruled in favor of the platforms in both cases, but they did so on extremely narrow grounds, using a legal principle called causation.
So wait, they didn't rule on the Section 230 immunity question at all.
They avoided it entirely. In the Tumney case, the court concluded that these generic recommendation systems and hosting platforms just didn't meet that high causation standard of the ATA. The link between Twitter's general hosting of extremist material, or Google's generalized recommendation system, and the specific terrorist attacks committed by ISIS was deemed too attenuated.
Too indirect.
Exactly. In essence, the court said that while the algorithms were certainly recommending content, they were too broad and ubiquitous to be considered knowing, targeted assistance to that specific terrorist act.
That's a huge distinction. So by ruling that the platforms hadn't aided and abetted under the ATA, they never had to even consider the more fundamental question of whether the algorithm's recommendations were protected by Section 230.
They found an off-ramp. And the core legal uncertainty, whether an algorithm is protected passive hosting or unprotected active development, remained completely intact. And this failure to address the core 230 problem is precisely what has fueled the most aggressive reform proposals in Congress, the targeted algorithmic liability hack.
Let's define this hack proposal, because this is the idea that's gaining so much traction. It's the idea that we can surgically remove immunity just for the algorithms themselves, targeting the economic incentive.
It's a very focused approach. These proposals seek to sunset Section 230 immunity specifically for the proprietary, profit-maximizing algorithmic amplification used by dominant social media entities.
So they're not going after hosting in general.
No. They recognize that these algorithms are designed to maximize engagement, and that maximizing engagement often means maximizing outrage, conspiracy, or extremist content, simply because that's what drives clicks and watch time.
So this is a structural difference. It doesn't target what I post as a user. It targets the platform's own proprietary code that decides to push my post into millions of other people's feeds.
Precisely. It targets the platform's proprietary conduct, the specific mechanism of amplification that their own engineers designed purely for maximizing revenue. Proposals like the Protecting Americans from Dangerous Algorithms Act are designed to deny immunity in civil actions related to, say, civil rights or terrorism if platforms use algorithms to sort, recommend, or rank third-party content.
The message seems to be, If you design your systems to prioritize dangerous content for profit, you lose the shield for that specific proprietary action.
That's the core idea of the hack.
Okay, so given the increasing scrutiny and the Supreme Court's reluctance to clarify this whole algorithmic question, Congress and the Department of Justice have been drafting their own blueprints to fix what they see as Section 230's failures.
Yes, let's look at three major categories of these proposed reforms.
Let's start with the one aimed at transparency. The Platform Accountability and Consumer Transparency Act, or the PACT Act. This seems to be aimed at the widespread consumer complaint that content moderation is just opaque and arbitrary.
That's the goal. The intention is to force accountability.
Yeah.
And the transparency requirements considered in the PACT Act are, well, they're extensive.
How extensive?
They include implementing statutory standards for content moderation policies that users can actually read and understand, establishing mandatory, easily accessible complaint systems, we're talking toll-free hotlines and web-based mechanisms, and providing users with a statutorily guaranteed right to appeal content moderation decisions.
And the data collection requirements are massive. This creates that compliance burden that critics argue is the real killer for smaller companies.
It's absolutely massive. The bill would mandate quarterly public reporting on these exhaustive data metrics. I mean, just imagine the logistical nightmare. Platforms would have to detail the number of complaints flagged by users, by their own employees, by contractors, by automated systems, and even by foreign governments. And on top of that, they'd need to document the country of origin for the content that's being flagged and track the disposition of every single one of those complaints.
Let's put that compliance burden in context. Critics argue this would sweep in thousands of small businesses, defined as any website with more than about 33,000 daily visitors and $12 million in annual revenue.
And consider the scale of the task.
Yeah.
Platforms like Facebook, Twitter, now X, and YouTube, they take action on literally billions of posts and accounts every 90 days.
Billions.
Billions. So demanding detailed, auditable record keeping for every single individual action, every complaint, every automated decision would impose what critics accurately call a daunting logistical and economic tax. Only the very largest incumbents with massive legal and engineering departments could possibly handle it.
Which instantly creates these artificial barriers to entry for any smaller competitor.
Exactly. In terms of liability, the PACT Act also tried to move the goalposts on removing illegal content. It intended to deny 230 protection if a website failed to remove illegal content or stop illegal activity within 24 hours of acquiring knowledge of it.
That's a massive shift.
Yeah.
Currently, 230 generally protects the platform even if they know about the content unless a specific carve-out applies.
Right. The PACT Act essentially introduces a duty to act and to act quickly. And this is where the legal nuance really matters. You have two kinds of knowledge. Actual knowledge. A user specifically reports a terrorist threat at a specific URL and constructive knowledge, where a platform should have known because the content was widely reported or algorithmically identified.
And would the PACT Act require platforms to actively search for illegal content?
Well, the PACT Act included language saying that affirmative fact-seeking is not required. But critics fear that by establishing a 24-hour clock once knowledge is acquired, it practically mandates monitoring anyway. If they miss an obvious piece of illegal content, a plaintiff could just argue they had constructive knowledge and failed the 24-hour test.
Managing that kind of clock for a global user base seems impossible.
It means either massive overhiring of human moderators or relying entirely on automated scanning, which brings us to a whole other debate about privacy.
Okay, let's move to the second major reform proposal, the EARN IT Act. This one represents the legislative response to the crisis of child sexual exploitation materials, or CSAM.
The goal here is unassailable. I mean, ensuring platforms are held responsible for facilitating or ignoring illegal content concerning children. But the methods proposed are what fundamentally conflict with the original purpose of Section 230.
Because they're so intrusive.
Deeply intrusive. The bill seeks to remove the 230 shield if platforms fail to follow government-mandated best practices for detecting and reporting CSAM. And critics argue these standards would require websites and even infrastructure providers to undertake several affirmative monitoring duties.
What are those specific requirements?
They include demands to preserve specified user-created content and location data, developing robust internal systems for prioritizing reports, training moderators extensively, and, this is the really controversial part, implementing age rating and age gating systems that would cover all online content.
And the technology that would be needed for this is client-side scanning.
That's what critics argue it would require.
Yeah.
Essentially, checking your content on your device before it's even encrypted and uploaded to ensure it doesn't match a known database of illegal images.
This sounds exactly like forcing platforms into the positions Section 230 was designed to prevent, making them mandatory, private content police who are responsible for searching the entire haystack.
It is the ultimate reversal of the moderator's dilemma. Critics argue that these requirements, especially the duty to prevent and disrupt user activity, amount to a wide-ranging duty to actively monitor all incoming user-created content, to find the illegal material, the needle. The entire encrypted private haystack must be searched.
And the unintended consequence for things like real-time communication and privacy would be devastating.
Devastating. If platforms have to do this monitoring, user posts might have to be held in suspense pending review, which slows down real-time communication. And the liability risk for any failure would lead to the immediate elimination of any post or communication that creates even a potential risk, even if it's constitutionally protected speech. The fundamental issue is that mandatory universal monitoring just undermines the very privacy and open communication the internet was built on.
Okay, so we have the PATT Act and the EARN IT Act. What's the third category of reform?
Well, in 2020, the Department of Justice provided its own comprehensive review. They laid out 4 distinct categories of reform that it believed were ripe for reform, designed to be more surgical, to realign the scope of Section 230 without triggering a total collapse.
Let's start with their focus on genuinely bad actors.
Their first priority was incentivizing addressing illicit content. This is where they formally introduced the idea of the Bad Samaritan carve-out.
A bad Samaritan carve-out.
Right. This would deny immunity to platforms that purposefully facilitate or solicit federal criminal content. They aren't just hosting, they're actively encouraging or building features specifically for illicit activity. They also recommended specific carve-outs for the most egregious content, like child abuse, terrorism, and cyberstalking.
And importantly, removing immunity if a platform has actual knowledge of unlawful content and fails to act.
Yes, this targets willful blindness without punishing good faith moderation.
The second area addresses government enforcement, distinguishing federal action from private lawsuits.
Right. They recommended clarifying federal civil enforcement. The DOJ wants to make it explicitly clear that Section 230 immunity does not apply to civil enforcement actions brought by the federal government.
That's a crucial distinction.
It is. While a private citizen might still be blocked by 230 from suing, the government, through agencies like the FTC or the DOJ, should be able to sue platforms for violations related to, say, consumer protection, fraud, or civil rights, without the platform hiding behind the 230 shield.
And their third point dives into the power dynamic and market competition.
Correct. Their third point was to promote competition by disallowing Section 230 protections in relation to federal antitrust claims.
That's a fascinating recommendation. It seems like a direct attempt to use 230 reform as an anti-monopoly tool.
It absolutely is. Platforms currently argue that antitrust liability, the claim that their market dominance was built on anti-competitive behavior, is related to their publishing decisions, and so they can use Section 230 as a defense. Removing this immunity would open up a massive new avenue for smaller competitors to challenge large platforms based on harm to competition rather than on third-party speech.
It forces them to defend their market position on its merits.
Exactly, separate from their role as a host.
And finally, the fourth point circles back to that political critique we hear so much about. Promote transparency.
They recommended requiring platforms to disclose their enforcement data in a standardized way. This is intended to directly address those widespread concerns that platforms discriminate against certain political viewpoints in their content moderation.
So detailed, auditable disclosure would let the public and policymakers see if the rules are being enforced fairly.
That's the idea, to see if there's any bias against specific political speech.
We've seen the extensive legislative proposals, many of them surgical, highly motivated, but history shows that when you try to radically regulate the internet, it often has massive, unforeseen side effects. What are the potential fallout scenarios if Section 230 is radically changed or just removed entirely?
The potential consequences are often exactly the opposite of what the reforms intend. The most dangerous potential outcome is the risk of centralization.
More power to the biggest players.
Yes. This is the core critique leveled against most of these reforms. Imposing massive compliance costs, like the extensive monitoring and detailed reporting we talked about for the PATT and EARN IT Acts, It doesn't hurt Google or Facebook. It only hurts their competitors.
Because the large incumbents are the only ones who can afford the army of lawyers and engineers needed to meet those standards.
Precisely. Imposing these costs creates artificial barriers to entry. The large platforms have the deepest pockets and the existing infrastructure to manage billions of moderation decisions and all the subsequent litigation. Any increase in liability or regulatory complexity just further entrenches their market position. It acts like a moat that protects them and chokes off competition and innovation from smaller firms and startups.
The argument is, if you want to break up big tech, don't give them more regulatory burdens that only they can afford to meet.
You're just cementing their dominance.
And this circles us right back to the original nightmare that Section 230 was created to solve, the censorship feedback loop.
Right. If you remove the protections for moderation, or if you dramatically increase the liability risks, for instance, for using recommendation algorithms, platforms are immediately forced back into that pre-prodigy posture.
The fear of lawsuits takes over.
The fear of costly lawsuits, discovery, and massive verdicts would compel platforms to adopt a zero-tolerance policy. They would simply over-moderate and suppress any constitutionally protected speech that carries even the slightest risk of triggering civil liability.
Which creates a severe chilling effect on innovation and speech.
A huge one. Instead of a vibrant, open marketplace of ideas, power shifts decisively from the user to the platform. They become maximalist gatekeepers, choosing to err on the side of caution and removal every single time, stifling legitimate public discourse just to avoid legal costs.
And this brings us to the massive, unavoidable First Amendment conflict. Platforms argue that the choices they make, the selection, arrangement, and presentation of information, even when it's done through algorithms, constitutes protected editorial discretion under the First Amendment, just like a traditional newspaper editor.
This is where the constitutional fight becomes fiercest. If you view an algorithm as the judgment of the company's engineers, encoded in the algorithms, about how to select and arrange third-party speech, then regulating that algorithm is, in effect, regulating speech itself.
Which triggers the highest level of constitutional scrutiny.
Right. It's very hard to regulate the algorithms without regulating the editorial decisions they represent.
And the Supreme Court has been waiting to address this, but the constitutional crisis is already visible in the lower courts. They seem fundamentally split on this idea. Let's break down the conflicting rulings from the 5th and 11th Circuits regarding state laws that try to restrict content moderation.
This is crucial for understanding the constitutional implications of any reform. First, you have the Fifth Circuit's ruling, which actually upheld a Texas law that prevents large social media platforms from censoring speech based on political viewpoint.
Okay, what was the Fifth Circuit's reasoning for that?
They adopted a highly restrictive view of the platform's role. They concluded that large social media platforms exercise virtually no editorial control or judgment. Instead, they argued that these platforms are more akin to common carriers, like telephone companies, because of their massive market power and the standardized way they operate.
So in their view, the platforms are just a utility.
Yes. In the Fifth Circuit's view, because the platforms merely host other people's views and don't inject their own, their moderation decisions are not protected editorial speech. They're just regulating access to a utility, and so the state can regulate what they carry.
But the 11th Circuit took the exact opposite view when it looked at a similar law in Florida.
They did. The 11th Circuit struck down the state law, concluding that when social media platforms disclose, publish, or disseminate information, they engage in speech within the meaning of the First Amendment.
So they saw moderation as an act of speech.
Yes. The 11th Circuit emphasized that even complex, automated moderation decisions are still the result of human-coded policies and judgment. They viewed moderation decisions, the choice of what content to keep, what to promote, or what to remove, as protected editorial discretion. Just like a newspaper choosing which op-eds to run, or a bookstore choosing which books to stock.
And the Supreme Court has now granted review of these conflicting cases.
Which means the constitutional question of what a platform actually is set to be decided, regardless of what Congress does with Section 230.
So here's the ultimate paradox. Even if Congress repealed Section 230 tomorrow, platforms would still have the robust protection of the First Amendment to fall back on.
That's the absolute truth. Repealing 230 doesn't guarantee liability. What it guarantees is massive uncertainty and a prolonged period of extremely costly litigation, as courts would have to reestablish common law standards under the shadow of the First Amendment, which generally rejects strict liability for passive distributors like booksellers.
So the immediate consequence of repeal would not be accountability.
It would be widespread immediate collateral censorship driven by legal uncertainty.
We've charted this dramatic journey of Section 230. From solving the moderator's dilemma back in 1996, protecting this nascent thing called the internet, to becoming the central point of failure in the age of algorithmic giants, where the stakes are measured in billions of users and trillions of dollars in market value.
The debate is indeed no longer about whether Prodigy should be liable for a single defamatory post about a fraudulent investor. It's about the economic machinery of engagement, driven by these sophisticated proprietary algorithms and the profound consequences for public safety and our democracy. Critical thinking is just so essential in navigating this complex world.
And knowledge is most valuable when it's understood and applied.
Right. And the entire modern internet, the one with Facebook, YouTube, and TikTok, it has always existed with Section 230 in place.
Yeah.
This makes it structurally impossible to know with any certainty how platforms, if they were stripped of the shield, would truly react beyond that immediate defensive reflex to just censor everything and centralize power.
So the question for you to mull over as you process this deep dive is this. If the sheer volume of user-generated content makes human monitoring completely impossible, and if algorithms which select and arrange information for profit are themselves protected as editorial speech by the Constitution, where exactly is the clear objective point, the material contribution, at which a platform's profit-driven design should trigger legal liability?
Or is the complexity of our digital infrastructure now simply too great for 1996 legislation, however elegant it once was to contain?